deals with that. All right, with that, I'm going to turn this over to Joe.
Hello, everybody. I hope you can hear me as well. Can I get a yes in the chat, please, if you can hear me? Hey, there you guys are. Thanks for the yeses. I've seen hundreds of you responding yes. I appreciate that. Seems like we were just here, but it's a couple of months since we last spoke. To get you up to date on what's been happening and transpiring since we last spoke, I'll give you a brief rundown of what's happened. Of course, DOJ proposed regulations for assault weapons, as you see right there, on December 30th. We had another one of these conversations on January 10th, the day after we, on behalf of the NRA and the CRPA, provided OAL a letter, a rather lengthy letter, detailing all of the problems with DOJ's, actually not all of the problems. We left some of that stuff out. The letter was so long. But nevertheless, we detailed a lot of the problems with the regulations for a while. We heard nothing until DOJ withdrew their regulations back in February. And as the middle of the slide says, well, nothing happened for a period of time. We've heard through various sources that they were being worked on, that potentially changes were being made, that they were going to come out any day now. Still nothing. Until last week, when we got dropped on us the new, or we gained at least wind of new regulations being submitted to OAL. And there was a great fervor activity surrounding those contacts. And not only ourselves, but other groups contacted DOJ, who outright refused to provide us copies of the proposed regulations. We reached out to OAL, and thankfully they provided copies to everybody making inquiries of those regulations on May 18th. And that kind of leads us up today. Well, last but not least, DOJ then, I guess, probably seeing the writing on the wall, and hello to my friends at DOJ who I'm sure are listening in. DOJ seeing the writing on the wall about, at least this is when I noticed it, May 22nd made the regulations available on their website after telling us and other groups that they were going to outright refuse access to those regulations until they were California law and published. Lo and behold, here we sit, at least here I sit in my office, talking to you about these proposed regulations. The thing that struck me first and foremost about these regulations is I don't know why it took them 3 months to get these regulations out to us, because very little has changed from the regulations that were proposed in December until now, to the point where most of the stuff we discussed about those regulations back in January is still pretty viable. To that end, I'm not going to be getting into too great a detail about the specifics involving the regulations like I did last time, because a lot of that information is still good, viable, and like I said, DOJ hasn't changed much. What I'm assuming they're waiting for those 3 months is one of two things. Either the money in order for this registration process to proceed, partly because the budget should be getting approved here pretty soon, and that will allow DOJ to acquire the employees they need to start accepting registrations, reviewing registrations, starting looking at pictures of all these firearms that they're requesting to be submitted. And then, of course, they needed to, I would expect, fully finalize the registration process through the CRIS website and DOJ. I'm assuming it's a couple of both of those things. We don't know for sure, but that would, at least in my mind, be the reason why we've waited so long for basically regulations that are virtually unchanged from what they proposed back in December and we talked about in January.
Joe,
and so
let me
that's
interrupt
what
for a second.
Go ahead.
Just so we're getting some questions about what the OAL is. The OAL is the Office of Administrative Law. It's the executive agency of the government that approves regulations, executive/administrative regulations that are submitted by other regulatory bodies. So you pass a law by the legislature, and then to the extent that law needs additional fleshing out, so to speak, the agency in charge of enforcing the law or implementing the law drafts these regulations. The regulations then, before they can become finalized and be published in the California Code of Regulations, has to go through the Office of Administrative Law, which sometimes is very scrupulous in reviewing those regulations and making sure they comply with all the requirements of the Administrative Procedures Act and all the other laws that apply to finalizing regulations. And sometimes, really, it seems like rubber stamps some things. Our biggest dispute with the DOJ over these regulations is that we believe it should have gone through a public hearing and comment period, and there should have been an opportunity for people to weigh in and for the DOJ to respond to those comments as the Administrative Procedures Act requires. The DOJ is taking the position that their entire regulatory scheme is exempt from the Public Comment and Administrative Procedures Act and can just be pushed through the OAL. So we're contesting that with the OAL, and we'll see what happens. Sorry to go off on that tangent, but we're getting a lot of questions about the process.
No, absolutely, Chuck. Thank you for doing that. And I apologize to you all for kind of skipping over that. And thanks, Matt Scabro, who's also monitoring from our office chat, and he posted some of that information as well. But yeah, if I'm being obtuse, overly broad, please feel free to ask chat. I'm trying to juggle about 20 balls while looking at the slides, talking to you, coming up with the stuff off the top of my head and things like that. So feel free to ask chat. Like I said, Matt Cabrero, another attorney in our office is monitoring that. I may, on the off chance, see the questions, but like I said, it's really hard, and there are a lot of you asking questions. Chat moves pretty quickly for me to be able to see. But basically, what are we talking about? What are the firearms we are dealing with here? Well, if we go by the Penal Code, and you'll see why I'm specifying going by the Penal Code here, we're really talking about two different types or two different categories of firearms that are now considered assault weapons under California law. And so what we had happen last year was that the legislature changed the definition of an assault weapon for two of those definitions, and you have those right there. They got rid of the quote-unquote capacity to accept a detachable magazine language and instead inserted does not have a fixed magazine but has any of the following for both semi-automatic centerfire rifles and semi-automatic pistols. Other than that, the definition of an assault weapon was unchanged, at least according to California Penal Code and the still existing regulations. In other words, the firearms that people had commonly and had been able to purchase for years that weren't considered to have a quote-unquote detachable magazine, but instead were not, or at least considered non-detachable or not detachable by virtue of installing a bullet button. And for those of you who may not know, but I'm assuming if you're chiming into this, you probably do. A bullet button is a device that either replaces or covers your standard magazine release. And in so doing, in order to get that magazine released from the firearm, you have to use a tool. Well, current and the regulations that were passed back in the early 2000s basically said that if you had to have a tool to remove your magazine, and of course the most common tool was a bullet tip, hence the phrase that was coined bullet button, if you had to use a tool to remove your magazine, your firearm was not considered to have a detachable magazine. And so therefore, these firearms were taken out of the definition of assault weapon by virtue of having those devices installed upon them. Again, I understand that I'm probably covering a lot of things a lot of you are aware of, but I'm covering all my bases to make sure everybody's kind of up to speed as to where we are now. However, the legislature then changed the law on us and required those firearms to have a fixed magazine, and those without a fixed magazine that for rifles were semi-automatic, centerfire, and had one additional feature. And I'll go back to the slide to point out the features that we will talk about. Has pistol grip, thumbhole stock, folding collapsible or telescoping stock, grenade launcher, not my suggestion to have a grenade launcher on your firearm, flare launcher, forward pistol grip for rifles, and then of course for pistols, if it's semi-automatic and does not have a fixed magazine and has one of the following or more features: threaded barrel, second hand grip, barrel shroud, or capacity to accept the detachable magazine outside of the pistol grip, those are now considered to be quote-unquote assault weapons. And so moving back to where we were now, what does this fixed magazine require? Well, the legislature decided to define fixed magazine to that definition you see in front of you. It's a ammunition feeding device contained in or permanently attached to a firearm in such a way that the device cannot be removed without disassembly of the firearm action. In other words, they redefined the definition of assault weapon, causing, for almost all intents and purposes, those firearms that have bullet buttons attached to them, those are now, as of January 1st, considered assault weapons in California, even if they require a tool to remove them, because you're removing a tool or using a tool to remove those magazines, you're not, quote-unquote, disassembling the firearm action. And then, of course, if that firearm has any of those nasty features I mentioned, it is now considered an assault weapon. But these laws did not change the definition of an assault weapon for all other intents and purposes. Your make model assault weapons, still considered assault weapons. Semi-automatic centerfire rifles with fixed magazines capable of accepting more than 10 rounds, still assault weapons. Semi-automatic centerfire rifles less than 30 inches, still assault weapons. For your pistols, semi-automatic with fixed magazines capable of accepting more than 10 rounds, still considered assault weapons. And then, of course, for shotguns, the law has not changed, DOJ. That law is still restricting semi-automatic shotguns that have both of the following: folding telescoping stocks and pistol grip, thumbhole stock, or vertical hand grip. It's a semi-automatic shotgun with a detachable magazine is still considered an assault weapon, and of course any shotgun with a revolving cylinder. The definition of assault weapon has not changed under the Penal Code for any of those firearms. And so moving forward, I think we've stressed this enough, what is now considered an assault weapon by virtue of the change. I don't need to repeat myself for purposes of that. Again, watch out for that grenade launcher. But in moving forward, those of you who are now in possession of firearms that as of January 1st are now considered assault weapons, well, you're in possession of an assault weapon. However, there is a grace period provided in the code as well. So provided you possessed that firearm that as of January 1st meets the definition of an assault weapon, you can continue to possess that firearm in that configuration up to and through December 31st of this year. However, January 1st of next year rolls along and that firearm is still in a configuration that causes it to meet the definition of an assault weapon. You are in violation of California law. Now, there are a couple of things you can do about that, and I've seen multiple times people asking questions about modifications and what they can do about that and what they need to do. We'll talk and at least touch upon that situation here moving forward. And lo and behold, if you wanted to continue to possess that firearm in its configuration that is considered to be now, as a result of the change in the law, an assault weapon, the legislature made it possible for you to register those firearms as assault weapons with the California Department of Justice, and as Chuck alluded to already, put the onus on the California Department of Justice to create regulations exempt from the APA for the registration of those firearms. And I emphasize registration here because, like Chuck said, what we're seeing in these regulations, and again, these regulations are very little modified from what we saw back in December and January. DOJ has exceeded the scope of the regulations and gone beyond just the requirements for registration. They've redefined, and I'll talk about some of these redefinitions that are pertinent here. Of course, you want me to go into further detail about a lot of the definitions. You can tune back in to the webinar that we did back in January. That is still available on the CRPA website. And I go into greater detail about those regulations and the problems with them. But nevertheless, like Chuck and I just said now, DOJ has gone way beyond just the regulations for registration and have redefined terms, have extended the definition of assault weapons, and I'll talk about that as well, to things that as of January 1st were not considered assault weapons, and then lo and behold, through the regulations, if they are to be accepted by OAL and become California law, it would change the definition, and more firearms would be considered assault weapons as a result. And so what Sean has mentioned, what I'll be mentioning here and probably moving forward, there are going to be a lot of firearms that are now considered assault weapons that were not considered assault weapons before, as soon as these regulations, if they do take place, take place. But nevertheless, going back half a second, there was a lot of concern for a lot of people when we're talking about what constituted a fixed magazine, and in that definition, embedded in that definition is the phrase disassembly of the firearm action. And if you have a firearm that requires you to, quote-unquote, disassemble the firearm's action to remove the magazine, well, that magazine was considered fixed. But what the heck disassembly of the firearm action meant was anybody's guess. Well, DOJ defined it before, back in January and December, and have kept that definition consistent with these new proposed regulations. As a result, what we discussed back in January still stands. So that those aftermarket features, as you've probably been made aware, that require, at least for the AR platform, for you to either tilt or pivot your upper receiver up from your lower receiver before that magazine can be released, that would be consistent with a quote-unquote fixed magazine. That should suffice to make your firearm, I'm going to use quotes a lot here, California compliant. And so the AR mag lock and some of those other devices that often push against or prevent you from releasing the magazine while the firearm is fully assembled, or at least the minimum, the upper is tilted back down onto the lower receiver for the AR platform, and then the only way for you to release those magazines is for you to tilt up and or remove the upper receiver from the lower receiver. Those parts are still considered so-called California compliant. In other words, cause your firearm to have a fixed magazine as opposed to a not fixed magazine, or a non-fixed magazine, probably a better way for me to phrase that. Also, we noticed for purposes of the definitions, DOJ went into detail about what they consider semi-automatic. And if you'll remember the definition of an assault weapon for both the rifles and the pistols, the prerequisite for all of those definitions of a firearm meeting the definition of an assault weapon is that it is quote-unquote semi-automatic. And again, this definition is virtually unchanged from what they proposed back in December. And the thing to point out there is that they define semi-automatic, but then they say that if you have a semi-automatic and it's lacking in certain parts that are crucial, or the parts listed there that would cause the firearm either to not function or work, or the firearm is disassembled, it is not considered semi-automatic. In other words, if the firearm does not function or is taken apart, it cannot and should not be considered semi-automatic. And because the firearm is not considered semi-automatic, it is, as a result, should not be considered an assault weapon under California law. Great. I applaud DOJ's effort in that definition. I agree with it. I know it's been their position for a number of years about semi-automatic, and I agree with that definition, at least, as to what constitutes a semi-automatic firearm. However, the possession of the parts can potentially still prove to be a problem. Just ask Mr. Wynn. Mr. Wynn was a defendant out of Orange County who had all of the, he actually didn't even have the completed parts to finish making an assault weapon. He had attempted to make a firearm out of an 80% or incomplete parts. Lo and behold, law enforcement showed up. And then Mr. Wynn took them on a guided tour of his parts and basically stated his intention to make a quote-unquote AK-47. And what the Orange County District Attorney did in prosecuting him was rather clever, because they initially tried to charge him with possession of an assault weapon and manufacturing of an assault weapon. And his defense attorneys rather cleverly pointed out, well, he's not in possession of an assault weapon, he has the parts. He didn't make an assault weapon, he has the parts. And so the DA's office pivoted, and they basically said, okay, he doesn't have possession of an assault weapon, and he didn't make an assault weapon. However, he attempted to possess, and he attempted to make an assault weapon. And he basically just told law enforcement that's exactly what he was planning on doing. And he got convicted. And there was an appeal, and they upheld the conviction, because Mr. Wynn, unfortunately, served himself up on a platter, saying, yes, it is my intention to make this firearm, and the court determined a quote-unquote AK-47 to be an assault weapon. And so stating that intent, they prosecuted him for attempted manufacturing and attempted possession. The long story short for Mr. Wynn would be, if law enforcement comes across you and your disassembled firearm, don't talk to them. Don't have any conversations with them about what your intent, what your plans are, and what you're going to be doing with those firearms. Because while a disassembled semi-automatic firearm is not considered semi-automatic and as a result should not be considered an assault weapon, if they gleam or have any inkling that your intent is to put the firearm together in an illegal configuration, that could very well be enough to sink you in the eyes of law enforcement, or especially a prosecutor, for attempt. And I see one question, I don't think Matt had a chance to address it, but I'll do it right here. Stripped receiver, absolutely. A stripped receiver would be, well, taken apart. It's missing vital components for it to function. As a result, a stripped receiver is not semi-automatic. It should not be considered an assault weapon. You're going to notice I said should a lot. I have a sinking suspicion that in my responsibilities here as being both responsible for regulatory compliance and criminal defense work, I will see and we will be contacted by, and I hope it's none of you listening to my voice right now, someone who has not only been arrested but potentially prosecuted for possessing the parts of an assault weapon, and either that you are getting, or that person is, getting prosecuted for possession of the parts, which, like I just said, shouldn't be a prosecution, or attempted possession or manufacturing of an assault weapon for possessing all the parts. That should not happen. Will it? Probably. I see prosecutions for absurd things relating to firearms and firearm laws all the time. But nevertheless, that is one potential option for those of you who may not wanting to register their firearms as assault weapons to take. Taking the firearm apart may be a viable option, but of course you will never be able to put that firearm back together in a configuration that causes it to meet the definition of an assault weapon in the state of California, barring either a substantial legislative change or, if we are successful in the lawsuits that we have going challenging the assault weapon laws. Basically, you have the parts. Congratulations. If you want to put them back together in a configuration that causes that firearm to meet an assault weapon, my strong advice would be you only do so outside of the great state of California. Your possession of those parts and assembling them into an assault weapon configuration would be a violation of California law, and potentially, like Mr. Wynn originally was prosecuted for, possession of an assault weapon and manufacturing if you complete that firearm in an illegal configuration. But in moving forward, the ability to accept a detachable magazine. This is the problem we had last time around. DOJ did not change their definition. You will see the phrase ability to accept a detachable magazine, and I mentioned it once before, in the context of shotguns. A shotgun that has the ability to, a semi-automatic shotgun that has the ability to accept a detachable magazine is considered an assault weapon under the current definition of assault weapon in California. Of course, as I mentioned before, detachable magazine was defined and currently is a magazine that does not require a tool to be removed. As a result, there were a number of shotguns, the Saiga shotgun being one of them, that had a bullet button attached to it, which usually would have a detachable magazine, but for the bullet button being installed, now do not have the ability to accept a detachable magazine, which is why you saw, and I would dare say even to this year, saw Saiga shotguns on the shelves of firearm dealers in the state of California, because those firearms with the bullet button attached to them were not considered to be assault weapons. And I'll level with you, they still aren't. The definition, as we discussed before, for these shotguns has not changed. The legislature did not change, modify, or amend the definition of assault weapon for shotguns. The regulations having to do with bullet buttons and detachable magazines are still California law. In other words, Saiga shotguns are not considered assault weapons right now. You should not be able to be prosecuted for possession of an assault weapon for possessing a bullet button Saiga shotgun, unless for whatever reason that firearm meets a different definition of assault weapon. That is current California law. DOJ is trying to change that. DOJ is trying to extend the definition of assault weapon to bullet button shotguns where the legislature has not. As a result, this definition, the one you're looking at right now, if it becomes California law, will create a new group of assault weapons virtually overnight. And those of you in possession of Saiga shotguns, if this definition does become the law, would now need to, like the people who have rifles and pistols, meeting the new definition of assault weapon, would need to register those firearms as assault weapons, or, like I said before, take them apart, or there's other ways to make your firearms California compliant, as we'll talk about here in a bit. I'm sorry, I lost my train of thought. And nevertheless, these firearms would be considered assault weapons if these regulations come into place. They are not now. The definition in California law as it exists, as I'm speaking to you right now, does not consider these types of firearms to be assault weapons. They do not meet that definition. I'm sorry, that's not the case, DOJ. But if this law changes, that would change the law with respect to these firearms, and these shotguns would then be considered assault weapons, not through the legislative process, but by virtue of the change in the regulations. DOJ actually does us a bit of a solid in saying, okay, these are the firearms, or these are the devices or things that they will not register. In the upcoming year, if you decide to register them with the California Department of Justice. Like I mentioned before, if you you were required to, if you wanted to avail yourself of the exception for you possessing an assault weapon this year, you had to have that firearm possessed on or before December 31st of last year. And so all of you with assault weapons, now defined as assault weapons this year, had to be in possession of those firearms last year. Of course, the question comes up, DOJ has redefined some of these regulations and is extending the definition of an assault weapon to semi-automatic shotguns with bullet buttons. Well, what if you acquire these firearms this year and lo and behold, as a result of these regulations, the law has changed on you? There's no good answer to that. But according to DOJ, you will not be able to register your firearm if, as a result of these new regulations, it automatically becomes an assault weapon by virtue of the regulations. So there's a potential problem there. You will not be, of course, able to register assault weapons that were required to be registered during the previous windows, your previous Category 1, 2, and 3s, your make and model assault weapons. I have substantial concerns that people will try to avail themselves of trying to register something like a Colt Sporter with DOJ. I expect that will set off all sorts of bells and whistles with the California Department of Justice and may prompt law enforcement to pay you a visit, because unfortunately for you, that firearm needed to be registered and assault weapon years and years ago, and they won't accept registration for that. Similar to the restrictions on assault weapons with detachable magazines. If you have your standard push-button magazine and you have the prohibited features, those firearms could not be registered this year. They were assault weapons back in the early 2000s. Featureless firearms. Actually, featureless is the phrase that DOJ uses, and I'll expand upon it right now. A lot of Californians are choosing, instead of registering their firearms, either, like I mentioned before, installing a device that quote-unquote fixes their magazine to the firearm, or affixing the magazine to the firearm themselves, or going quote-unquote featureless, using features that, or either one of two things, removing features that would cause the firearm to be an assault weapon, or installing features that do not meet the definitions of the prohibited features, fixing stocks or certain types of grips that are not considered pistol grips or telescoping or collapsible stocks. Actually, I should be using the phrase folding stocks, and making a featureless build. DOJ will not register those because they're not assault weapons. Once you remove the prohibiting features and take that firearm out of the definition of quote-unquote assault weapon, it's not an assault weapon. And therefore, there should be no reason to register, and DOJ is telling you right there that they won't. Moving forward, of course, fixed magazines that hold less than 10 rounds. Of course, the definition changed, requiring the firearm to have a fixed magazine. And the additional features, of course, if your firearm now has a fixed magazine, it's not considered an assault weapon as well, and as a result, they're not going to register it. As I mentioned before, taking the firearm apart or causing it not to be able to function will take the firearm out of the semi-automatic category, and as a result, it won't be considered to be an assault weapon as well. The last two are a bit odd, and I'll talk about briefly. Those firearms manufactured by a federally licensed manufacturer that doesn't have a serial number, DOJ will refuse to register as well. Likewise, those firearms manufactured yourself that don't have a serial number, you will first need to go through the process, according to the regulations, unfortunately, of getting a serial number and adding additional information about that firearm to the firearm, and then registering the firearm as an assault weapon. And there are, I'm certain, although probably not very many, firearms manufactured by licensed manufacturers that don't have serial numbers. I would expect and assume that DOJ would want you to follow the same process of someone who makes that firearm themselves in obtaining the serial number. Again, whether or not you want to do that and then go about that process is one entirely up to you. But nevertheless, DOJ will refuse to register those two types of firearms as well. So circling back around, California compliant or so-called featureless firearms, those do not have to be registered. If you do modify your firearm to make it quote-unquote California compliant or so-called featureless, firearms not considered an assault weapon, as a result would not need to be registered. I'm not going to get through all the nooks and crannies about all of the features and all of the clever devices and things that people attach to their firearms. I see a lot of you asking, I'm sorry to say there are so many different types of devices and things and features or featureless builds that there's no way for me to do this. Keeping in mind I'm only on slide 23, we're almost an hour in. We still got a lot to talk about. And also, as I mentioned before, taking those firearms apart, causing them not to function, and as a result, not semi-automatic, would not be considered an assault weapon as well. But again, remember poor Mr. Nguyen, who was prosecuted for the attempted possession and attempted manufacture because law enforcement gleaned or gained wind of his intent to complete his firearms. If law enforcement wants to talk to you about your firearms parts, and you're not the victim of a crime, you probably want to invoke your rights, not talk to them without an attorney being present. Certainly if they are coming and knocking on your door, wanting to look into your gun safe, sorry guys, you have a warrant? No, sorry guys, I'm not going to let you in. As a result, just be mindful of that. And I think Chuck's talking to everybody about the warnings about just refusing to comply. I will echo those for you, those of you who are not are able to look at or read into chat. As I mentioned before, handle criminal matters in our office. Even when you think you have a great argument to make, you have a Second Amendment backing you up, and you want to push this, my strong advice is not to. You probably have families, you probably have a lot of other good things going for you. Having to have a very serious conversation with me about pending criminal charges, typically when we're talking about assault weapons, felonies, are not conversations people enjoy having with me. I like to think I'm a likable guy. But nevertheless, those are very uncomfortable and awkward situations, and you're then very really looking at the possibility of potential, not just criminal charges, fines, potential jail time, of course having a criminal conviction on your record that will follow you around probably forever. Those are very real possibilities for noncompliance, and law enforcement stumbles across or comes across firearms in the most odd and ridiculous ways. But nevertheless, a person becomes prosecuted, gets arrested, has to post bail, and then starts talking to me about criminal retainers and having to handle felony charges in a lot of jurisdictions that are not too happy about firearms in general. So just keep that in mind. Know your rights, and then, of course, think very hard about whether or not you want to or decide to comply. Moving forward, if you go the route for registration, I'm going to switch gears a little bit. We kind of talked about what is an assault weapon briefly, ways to at least consider not registering or not having to register if you make your firearm California compliant, featureless, taking it apart. One thing I didn't mention, of course, is getting the gun out of Dodge. If the firearm's no longer located in the great state of California, it's not considered a California assault weapon anymore. However, that firearm ain't ever coming back into the great state of California in that configuration because, again, it's an assault weapon configuration, and once you bring it back in, you get yourself some problems. Of course, being mindful of the federal requirements of taking a firearm or either transferring or giving it to somebody outside the state. I'm not going to get into those. Sorry, guys. We're way too far in the weeds as it is. But nevertheless, that is another option. But now we're going to talk about registration. We always knew that the registration process, as is required by I'm sorry, Jeff. I'll refer to California as the great state of California. I am putting it in quotes, though, so trust me on that. We'll switch to gears. The Penal Code required these registrations to be electronic. Of course, DOJ, like I said before, had the daunting task to come up with the electronic registration process. There is an electronic process existing right now for a number of the forms that people commonly need to use when dealing with firearms, either for private party transfers or personal firearms eligibility checks. There is a computer system in a place right now. What DOJ has done is tacked on to that computer system for purposes of these registrations. Nevertheless, you need to, and DOJ is basically saying you need to create an account. Your process for doing that is here, and that process is relatively straightforward. Once you get into the system, and once it's available in the system, for registration of assault weapons, well, you're going to have to start filling out a whole bunch of information about yourself. And there it is. Your full name, first and last name are required. Address, which if your mailing address is separate from your residential, required to provide as well. Telephone number, they want at least one of those numbers, your home business or mobile, of course, date of birth, sex, weight, race. Oddly not required in the regulations, and it is not a required field, but they do have that there as well. Eye color, hair color, and then we get into a little odd area where they're going to ask about your military ID if you have one, California driver license ID number, U.S. citizen status, place of birth, country of citizenship, and your alien registration number or your I-94 number. Those last ones, as I pointed at the bottom, they are what you typically see at the bottom of 4473. And because, as I'll talk about at the end here, they're going to be doing a background check on you when you're applying to register your firearms. So the information at the bottom of the screen, though not typically laid out or though not laid out in the Penal Code or it's in the regs, but nevertheless, it's on the form because, again, they're going to want to be running a background check on you. And while we're talking about registration, a good segue here is for joint registration. The Penal Code has in the past and does currently allow for the quote-unquote joint registration of assault weapons owned by family members residing in the same household. Well, that's nice. But what exactly does that mean? Well, sure enough, DOJ has decided to define that. This definition is virtually unchanged from what we talked about in January, but it bears repeating. First of all, you're going to need to identify who the primary registrant is, and then provide the names and relationships for all the joint registrants on your registration form. And of course, DOJ points out that you need to reside in the same household and share the same address. Also, the joint registrant needs to be 18 years of age or older as of December 31st, because technically somebody under the age of 18 can't be in possession of a quote-unquote assault weapon after that time. Well, any time in general, truth be told. But nevertheless, they want to make sure the person to whom they're registering that firearm will be at least 18 before the end of the year. But here's where things get a little sticky, because they decided to define what exactly a family is. And I take a bit of an exception to that, because this definition is rather limited. Spouses, parents, children, parents, grandparents, grandchildren, domestic partners, and siblings. That's it. In a very liberal state that has a very broad view of what constitutes a family, this is a rather conservative and narrow definition as far as I'm concerned. A lot of families, a lot of households have extended family members residing with them that I would most certainly consider quote-unquote family members or family relationships. DOJ doesn't. These are the people with whom you may register assault weapons jointly. And as I mentioned before, if my in-laws had moved in with me, if I have an elderly uncle or aunt, cousins living with me, we're not going to be able to register those firearms with those other individuals. And here's the concern. Say if I register my assault weapon just to me, and I have my wife living there, if I were to leave and she has access to my assault weapon, technically she's in violation of California law, because at that point she's in possession of a firearm that meets the definition of an assault weapon, and it's not registered to her. Same thing goes for the in-laws, the aunts and uncles and cousins who may be residing with me. If I only can register the firearms to myself and my spouse, which, to give you an insight in my house, that's about it, and not my minor children, which I can't, if I have to have in-laws or aunts and uncles move in with me, if, of course, I or my wife leave and they have access to any of my firearms, specifically the assault weapon, they themselves are in violation of California law. I guess I mentioned there as well, while they're allowing for registration between siblings, of course you can't private party transfer firearms between siblings, but you can jointly register assault weapons. Okay, great. But it's just an odd distinction there. But we're not done, because you're going to need to provide information when you're registering these firearms jointly about you and proving to DOJ that you actually reside in the address where you're jointly residing with your family members. Keeping in mind, as that first one says, if you're just registering an assault weapon for yourself, you don't need to provide this additional information. However, if you're jointly registering firearms, all of the joint registrants will need to show that they have proof of address for the location where they're residing, so all the family members can prove up that they are in the quote-unquote same household. And the information to provide proof of address is any one of those things listed there. CCW, CNR license with your name and address on it, utility bills specified there, military permanent duty station orders, and the like. Everyone in registering the firearm when they're doing so jointly will need to provide proof of address. You will be able to attach that after you scan it into the application or the registration form. So just keep that in mind and keep those proofs of ID together, that all the registrants for joint registration will need to do that. And one last, well, at least one segue thing. DOJ in registering will also ask you a couple of other things. Whether or not you have built the firearm yourself. Of course, yes. That goes to the so-called ghost gun issue and the process by which you need to request the serial number and have it affixed to the firearm prior to registration. Of course, they're asking you about joint registration. And then, of course, each of the joint registrations will at least have to provide the information of with whom they are filing the registration jointly. And here's another odd thing. It appears, and I'm relatively certain, that each joint registrant will have to fill out registration for the assault weapon themselves. Someone needs to explain to DOJ what joint registration should mean, but nevertheless it appears that each joint registrant will need to fill out registration for each assault weapon themselves they're jointly registering, because they also ask, are you the primary registrant? If you are, each joint registrant will need to fill out their own registration form, and the primary registrant will need to provide each joint registrant the CRIS number provided associated with that firearms registration as an assault weapon. And then, like I said before, you need to specify for each one of the joint registrants with whom you are registering this firearm jointly. So in other words, if I was living with, unless my wife has something to tell me, if I'm living with my wife and, say, a brother and a sister, all in the same household, and we're going to register a firearm jointly between my wife and my brother and my sister, I'm going to be presumably filling out the firearm as the primary registrant, and then I'm going to be pointing out I'm going to be jointly registering this with my wife and then those two other people. And then, of course, they then will fill out the registration with my CRIS number associated with me and that registration themselves. And then, of course, notifying DOJ that I'm registering this firearm with Joe's wife, and my other sister or my brother. And then, of course, each one of us would need to fill out the registration for that firearm for that registration. And then, of course, when it comes to the firearms, DOJ wants to know a whole heck about that firearm. First of all, the type. Presumably this is a pull-down menu, but I'm assuming they want to know about rifle and pistol. They probably want to know about shotguns too, because they think shotguns are now assault weapons and need to be registered because of the redefinition of the regulations. The category, which is kind of odd considering that at least for rifles and pistols, the category really is only going to be semi-automatic, but there's a pull-down nonetheless. DOJ hasn't shown us what else is in that pull-down. It's going to be a little odd if they're asking for other information, but right now the only information I have right now is what information you need to provide for category is more than likely semi-automatic. The make, another pull-down menu. Model, go ahead and fill it in. Caliber, that would be another pull-down menu, but DOJ advises if you don't see your exact caliber, go ahead and get the closest thing to it, and then in the comment fields go ahead and say what that caliber is. And so if you have an odd caliber that you're going to be registering as an assault weapon, you don't see it in the pull-down menu, get the closest thing, and then in the comments go ahead and point out, okay, I have a discrepancy here. My caliber is actually this. You don't have that caliber in the pull-down. Color of the firearm, barrel length, and, of course, unit of measurement, and that's, of course, inches or millimeters. The magazine, again, an odd requirement because, again, you can see in the pull-down menu that it is, quote-unquote, non-fixed magazine, but I have no idea what other types of magazine release types DOJ is expecting us to fill in there. That will remain to be seen. Of course, cartridge, again, you'd think they'd be able to figure that out by caliber. And then on top of that, if we're talking about rimfire, at least for rifles, a rimfire rifle does not meet the definition of an assault weapon. For purposes of the newly changed laws, and for almost all intents and other purposes, unless we're talking about a make model rifle, that is rimfire. So that one is also odd why they're wanting you to specify center or rimfire for the registration. Serial number, of course, other number, though not required, and if there's no other numbers, don't worry about it. Of course, you have other markings on the firearm. You might want to specify it there or in the comment fields. Country, origin, and manufacturer. And then we get a little odd, because then DOJ wants to know the date you acquired the firearm, from whom, and that's a pull-down. I'm assuming they mentioned their firearm dealer, but since it's a pull-down, that remains to be seen. The address, zip code, city, and it appears that California is an autofill for state. Well, you could have acquired that firearm in other states, brought it into California as California compliant with a bullet button, and now meets an assault weapon, and you need to register it. Well, if DOJ is autofill in California for you, that remains to be seen. Well, why? And what are you supposed to do in those instances? Nevertheless, the information highlighted in red is potentially problematic because those appear to be required fields. If you don't recall, because you had this firearm for years, there's no guidance to say what is supposed to be filled there. I'm not in a position to provide you that information. I would hope that DOJ will still expect or accept you to provide at least your best determination, but keep in mind that these forms are filled out under penalty of perjury. And so guessing would not be what I'd suggest, but again, it doesn't appear that DOJ is giving us any alternatives. And on top of that, they ask you who you acquired the firearm from. If you acquired the firearm from Pookie down the street last week and now you're trying to register it as an assault weapon, and you say, okay, I acquired it last week from an individual and I don't know Pookie's address, so I just guess, I got myself a bit of a problem because I've just basically admitted to an illegal transfer involving an assault weapon. Not only did we not go through a dealer, but we transacted in an assault weapon, and I've just fed that information to the California Department of Justice. If you have any questions or concerns about that information, and information is very similar for the so-called ghost gun registration, I would suggest contacting an attorney and having them advise you how best to do that. I would hope DOJ, and I know you're listening, would provide additional clarification as to what is to be done in these situations, but right now we don't have it. And so as a result, we'll see what DOJ's position is and moving forward. Of course, DOJ wants additional information, and this one's a little odd. The example that they use is specific to a rifle, and these are all check boxes for the registration. They want you to check off what characteristics are attached to your firearm. I'm assuming that these characteristics are default as a result of the firearm, at least in the example, being a rifle. However, if it's not, then I don't know why you would check any of these boxes if you're trying to register a pistol. And so that remains to be seen as well. We don't know whether or not DOJ will have this changed if you're trying to register a pistol, and of course DOJ thinking an assault weapon needing to be registered. Whether that's going to change for those types of firearms as well, again, remains to be seen, but DOJ has provided no information, at least in the information they provided from the walkthrough for the CRIS website. Nevertheless, they want you to check what features are attached to your firearms, and those are there. Like I say below, I would strongly advise, or at least caution, when checking the box relating to grenade launcher and flare launcher. Because if you're admitting to trying to register a firearm with potentially a grenade launcher, I don't know what DOJ is going to do in that situation. I would hope they aren't going to start knocking on your door. Also, the odd thing to check is the one that's second from the bottom, semi-automatic centerfire rifle in this case. Overall length of less than 30 inches. Again, that definition did not change. DOJ's changing the measurements of that firearm with the regulations, but nevertheless, that change or that definition from Sullivan has not changed. And so whether or not DOJ is going to start accepting registrations for firearms, which for all intents and purposes had to have been registered back in 2001, that remains to be seen. But nevertheless, that box is there too. Again, I would strongly advise caution before checking that box because, again, semi-automatic centerfire rifles with overall lengths than 30 inches were assault weapons last year and the year before and the year before, and they're assault weapons now. Why that is a box to check is anybody's guess. I have a suspicion based on how a lot of these are phrased in DOJ's own website. The person putting these together or the people putting these registrations together were not familiar with the laws or the requirements of California law and kind of did it either by haphazardly reading through or not fully understanding the requirements for registration. But nevertheless, that box is there, and it's a bit of an issue. Why? As we mentioned in January, we have the requirements for pictures still present, unchanged from before. DOJ wants 4 clear digital photos of the firearm listed in the application, and what they want is basically right there. One of the bullet button, one of the firearm from front to back, or from, I guess, muzzle to end of the stock, or at least the end of the pistol, and then, of course, the 2 sides of the frame or receiver, more than likely depicting the manufacturer marks and any of the serial number or identifying marks placed on that firearm. DOJ, of course, is invoking their discretion to say whether or not they want or need photographs of other locations, but at a bare minimum, you need to have those 4. But like we had before, when they're asking for pictures, we still have those now. Although DOJ has cleaned it up a little bit, they do accept PDF, GIF, JPEGs. And I never heard of a PNG before, though that just shows I'm really not familiar with computers as much as I thought I was. So I don't know what that one is, but nevertheless, they do accept those 4 formats, keeping in mind that the size of the file cannot exceed 10 megabytes. But that's really all of the guidance they provide. There's not really much else with respect to, other than being clear what type of resolution, what type of backdrop, what exactly they mean from depicting from the muzzle to the end of the stocks. Is my picture on the right sufficient for that purpose? I don't know. They still don't have, and they don't have examples of pictures that they would expect you to follow, but nevertheless, you will be required to provide those 4 pictures at least, subject to, again, DOJ further request or clarification. And of course, as we mentioned before, the legislature said DOJ can charge up to $15 for this process per transaction. DOJ has said, thanks, we'll charge the full $15. Still no limit on the number of firearms you can do per transaction, but of course you need to pay online with a credit card. And of course DOJ still wants you to pay for copies of your registration if you fail to have them. But like I mentioned back in January, and I'm mentioning it again, once you have your copy of the registration, if that's the route you choose to go, make yourself copies and copies and copies. Make sure you have yourself extras. Keep one always with the firearm, potentially in the place you keep your records, in a safe, in the gun safe, not a bad place. Sometimes there's the hollow out in the stock. I know a lot of firearm owners choose to keep their registration located there so they don't have any problems in the future. Of course, DOJ's processing of this, and I realize we've gone over an hour, and we're 35 in. I'm going to speed things up a little bit. Some of the stuff I've discussed before. The processing of applications really hasn't changed from before. DOJ is required to start taking applications. Let's not try to chuckle when it says January 1st, 2017, and ending December 31st, because there's still no way for you to do this. These haven't been accepted yet. But nevertheless, DOJ will notify you that they've received and accepted for processing. It's being returned incomplete or it's been rejected. If they determine your application is incomplete, you have 30 days to correct that. If not, you need to resubmit. If DOJ gives you that window right before or up into and through that December 31st deadline, make sure you don't blow it, because if you were to fail to provide them the supplemental information they're looking for an incomplete application, you're not going to be able to file a new registration after December 31st. And so just be mindful of that 30-day window. If they have accepted your registration, like I mentioned before, but here we go, they are confirming that they will be doing a quote-unquote eligibility check on you. We have confirmation, at least through the paperwork for the CRIS website, that they will be doing a full-blown background check on you through the NICS system and the standard system that they avail themselves of through DOJ when they're running background checks as a point of contact state. At least they're referencing the NICS system in the CRIS information provided by DOJ. If you have concerns about your eligibility, I would strongly suggest you don't attempt to register a firearm as an assault weapon until you have those concerns satisfied. And because a great way to have DOJ show up at your door is try to register a firearm now meeting the definition of an assault weapon, and you come up, lo and behold, prohibited. So be mindful of that, and if you have any concerns about that, I would suggest at a minimum running a personal firearms eligibility check prior to attempting to register the assault weapon. Of course, talking to an attorney who knows the ins and outs of these restrictions would also be in your best interest. As I mentioned before, those firearms lacking in serial numbers, typically what we understand to be so-called 80% receivers, those two will need to be registered if they meet the definition of an assault weapon. But of course, if you've made the firearm yourself, there's a strong likelihood the serial number wasn't put on it by a licensed firearm dealer. And as a result, you need to go through the process DOJ laid out and I laid out in January in first acquiring the serial number from DOJ, having that serial number affixed to the firearm pursuant to the federal requirements, and then, of course, you need to affix additional, quote-unquote, additional information involving that firearm's registration. Typically, that's going to be your name and the information you're going to be providing to DOJ in applying for the serial number. You're going to need to put that information on the firearm. The requirements and the specifications for that will be are laid out both in the regulations, and I discussed them at length back in January in the previous webinar. Like I mentioned, is still available at the California Department of Justice. California Rifle and Pistol Association's website. So be mindful of those and those requirements. But some things do bear pointing out right now. When you're applying for that serial number, the form asks where you acquired this firearm from. I think for most of you, it will probably say, nobody, I made it myself. And so there are questions of, from whom did you acquire this firearm, and what's their address, and where did you get it from, should not be applicable. There are probably some of you who are in possession of firearms that are so old that the manufacturer did not need a federal firearms license for manufacturing, and then of course due to their age did not have the marking requirements DOJ wants and expects them to have. In those rare instances, pointing out the dealer from whom a firearm was purchased may be required. But of course you could have purchased that firearm at a time when even going through a dealer was not required. Again, I think that's going to be a rare instance. My concern is people trying to register firearms that were made up from 80% receivers, but they themselves did not make those firearms themselves, but were purchased from somebody else who made them on their behalf. That's a huge problem because a person can't make firearms for purposes of sales or making a firearm and then selling it according to ATF, because those individuals are considered engaged in the business of manufacturing firearms. So if you are in possession of a firearm that was built up, say by a friend or someone you know, and you didn't go through a background check, and you know that person probably doesn't have a manufacturer's license, and then they gave you that firearm that now meets the definition of an assault weapon, you have yourself some concerns. I would suggest, as I do at the bottom of that page, you might want to talk those concerns over with a licensed not firearm dealer, licensed attorney, because again, there's potential exposure for you for that type of activity in acquiring the firearm, and then of course most certainly for the person who potentially manufactured the firearm and then either gave or sold the firearm to you. So be mindful of that situation. If you have any questions about this, it's a little bit nuanced and highly specific, but be very careful for those of you who have the 80% you wish to register, or at least go about the process to get the serial number for and then register. Post-registration modifications, I know that's often a huge question when it comes to these issues. DOJ, like they did back in December and January, specify that the firearms you register with the bullet buttons cannot have their release mechanisms, meaning the bullet buttons for those firearms, altered. Only repairs or like-kind replacements are allowed. However, if you were to go about the process of deregistering those firearms, making them California compliant, you'd be able to do that then. But nevertheless, once the firearm, according to DOJ, is registered as an assault weapon, your removal of the bullet button is prohibited according to DOJ. They do not talk about the modification of any of the so-called mean and nasty features. And being very specific with respect to the modification of the magazine release mechanism and nothing else causes me to believe that you should be able to modify the firearm's other features, despite the fact that they would and could still be considered an assault weapon by virtue of those modifications. I am a little concerned about that based on what DOJ is asking people to do by specifying the prohibited features they have on the firearm when they register them. However, there does not appear to be any limiting language in the regulations about you removing anything else, like pistol grips or flash suppressors or telescoping or folding stocks. There does not appear to be any restrictions on your modification of those features, just the release mechanism for the magazine. So that is DOJ's position, at least for right now, with respect to the magazine release. No removing the bullet button after registration. However, it should be allowed for you to make modifications to, like I said, the pistol grips or the muzzle, muzzle attachment, I was about to say muzzle brake again, the flash suppressor, and stocks. And like I mentioned before, there is the possibility for deregistration. If you want to remove the firearm from the definition of an assault weapon, you may do that and then deregister the assault weapon. Of course, if you get rid of your assault weapon by transferring it to a licensed firearm dealer who can deal in assault weapons in this state, or to a licensed firearm dealer in another state, you may do so. You may also notify DOJ, hey, I am no longer in possession of this, or please deregister it because I've made modifications to that. We talked about that in the previous webinar. That is a potential option, but of course, once deregistered, you can't put all of the features back on that would cause it to be an assault weapon ever again. So just be mindful of those restrictions and requirements as well, but there is that possibility if you want to take that firearm out of the definition of an assault weapon and get the firearm out of the system as an assault weapon. That kind of about covers it for the assault weapon stuff. And just to have you here to give you a heads up on the pending laws. Sean mentioned this, of course, come July 1st. There's the restriction on the possession of large capacity magazines. That is still coming down the pipe. There may be challenges to that. Like Sean hinted about, there may very well be more regulations. As you may recall, there were regulations proposed right before Christmas having to do with large capacity magazines. We do not know, nor have we specific word, that DOJ is planning on springing additional regulations on us concerning large cap mags. We, of course, and working with the CRPA and NRA, will let you know if that were to happen as soon as we have those regulations. But right now, unknown whether or not there'll be no more regulations. And then, of course, there may very well be challenges to the restriction on the possession of large cap mags. That may or may not take place before then. And then, of course, the courts, within their discretion, are going to decide what they decide. So this is me as Joe, the defense attorney now, saying be very mindful of that. Don't count on it necessarily because we're still dealing with California courts. And then, of course, July 1st comes around and there hasn't been a stay in the ability to enforce or an injunction against anybody's ability to enforce those laws. The possession of large capacity magazines becomes a crime. There are certain jurisdictions right now that cause this to be a crime anyway, but nevertheless this will be a statewide ban. So be mindful of that. Again, you have a decision to make with respect to that. Keep your ear to the ground about alerts either through our office, of course, NRA CRPA, about what the status of that is. Of course, also on July 1st, the requirement for theft loss reporting goes into effect, and of course the restriction on falsely reporting firearms lost or stolen go into effect as well. I know I'm blazing through all of these, and I will be for the next couple of slides. I go into all of these requirements and restrictions in great detail in other webinars put on by the CRPA, still available on CRPA's website. So getting into the restrictions on large capacity magazines and theft loss reporting and false reporting restrictions, all of that is addressed by me. I appreciate those of you who might have listened to those previous ones or back around for the third time. My condolences. But nevertheless, I do cover that in great length as well. And then, of course, that really should say 2018. I apologize for that error. Yeah, it should be say January 1st, 2018. The restrictions on ammunition go into place. And so in order for you to purchase ammunition, it will need to be done through a so-called ammunition vendor, keeping in mind that those who possess California dealer's licenses for firearms are automatically considered vendors. But nevertheless, if you're looking to purchase ammunition, that transaction will almost in all cases, barring some limited exceptions, one notably for ranges, need to go through an ammunition vendor or a California licensed firearm dealer. No more are you going to be able to order that ammunition from outside the state and have it shipped directly to your home. You'll need to go through a vendor for those purposes. And of course, the transactions will need to be done face-to-face for sales. So again, internet and web purchases would need to go through a dealer or a vendor in California. Keep in mind that for those of you who are maybe selling ammunition now and are not a California licensed firearm dealer, Yeah, thank you, Matt, for clarifying that. Yes, it's 2018. I apologize for that typo, rather glaring typo. I apologize yet again for that. Those of you who are selling ammunition right now are not a licensed California firearm dealer. You will need to get yourself a vendor license if you want to continue that activity after January 1st. Again, there are notable exceptions, one of them being for licensed target facilities. But beyond that, DOJ hasn't come up with the regulations for you to get a vendor license yet. They were supposed to start that on July 1st. Their ability to do that appropriately and through the APA, the Administrative Procedures Act, which is, like Chuck said before, the OAL who reviews all of those activities, their time to start those regulations have passed. And so DOJ will not in a timely fashion opening the window for ammunition vendors to apply for their licenses, even though that was supposed to have started July 1st. I hope, again, DOJ, if you're listening, we're still looking for those. And the ammunition vendors are looking to get their licenses to have everything in place prior to January 1st. Again, that's 2018, not 17, as I mentioned before. But again, I go into great detail on the ammunition stuff, again, for the CRPA's previous webinar on that. More things to look forward to, and that one does have it accurately. 2018, you start having the ghost gun requirements, and then of course we're talking about firearms that individuals have manufactured for themselves. Of course, if these firearms currently meet the definition of an assault weapon, you have your work cut out for you for getting the serial number and those registered as assault weapon. However, come next year, if you have firearms that do not meet the definition of an assault weapon, but nevertheless, you made yourself, you're going to have to do a couple of things. After July 1st, 2018, you're not going to be able to make your own firearms for yourself without getting a Mother May I from DOJ. Of course, getting a serial number, affixing that to that firearm, and then giving DOJ confirmation that you affixed that serial number onto the firearm. And then those of you who are in possession at July 1st, 2018, of firearms you made yourself prior to that point, or at least lacking in the serial numbers or identifying marks, you'll need to apply to DOJ to have a serial number issued to you by them, have that serial number or identifying information affixed to that firearm, and show DOJ you did that by January 1st, 2019 at the latest. Again, I go into so-called ghost guns in great deal as well in the CRPA's webinars. And then last but not least, come July 1st, 2019, the ammo background checks and ammo purchaser registration information getting sent to DOJ go into effect, as does the third and final phase for the lead ammo ban for hunting. Again, go into this great deal in other lectures, and then of course the lead ammo stuff is addressed in, wait for it, hey, there it is, the book. We cover a lot of the laws that were changed last year. We didn't get a chance to go into the regulations that I covered just now because those just literally came out again last week. But the laws that changed as of last year's so-called Gunmageddon and Prop 63, we go into those in great deal in the book. So additional information you need to look at for purposes of seeing what the laws are and the requirements are, they're there. And like I said, for some of the more up-to-date changes, we do have a number of webinars available through CRPA for those purposes. Stay tuned. While we don't have any webinars planned here anytime soon, things can change at the drop of a hat in California when it comes to firearms laws. As a result, stay tuned. We will most certainly be sending out alerts through NRA and or CRPA about any pending legislation that people may face, we may face, and certainly regulations, if there's big changes with respect to either Peruta or our pending assault weapon and or large capacity magazine cases, or any other of the lawsuits we have planned in the works. You'll be getting news and alerts through CRPA. Good name there, Joe. Joe's asking about a 5th edition. We usually wait for our changes in it, or new editions following the legislative session. We will probably not do another one until, again, the fall like we normally do. But yes, we will be doing a 5th edition. I am almost certain, if for no other reason based on all these regulations. that are pending and proposed. The legislative session is still active. There are still some mean and nasty bills that are pending, especially for dealers. Give your dealers some love, guys. They're going to be having to deal with a lot of this stuff on top of the ammo stuff moving forward, and hopefully we have some common sense. I'm not holding my breath with the legislation, but we'll, of course, be addressing any changes in the legislation. That's it. Thank you for your time. By comparison to a lot of my previous webinars, this one's actually pretty brief. But thank you all for your time. We have very little drop-off in the group and in chat. Everybody throw Matt some love, who's been addressing your questions and concerns in chat as well. And Chuck, I've seen him mention, and yeah, get involved. Contact CRPA, ask you how you can help. It would also be fantastic as well, joining up with the NRA and CRPA. They make stuff like this possible. We do a lot of stuff behind and around the scenes that doesn't get on y'all's radar, but we are constantly working. I think we had at least 4 or 5 attorneys here well after 8 o'clock last night working on various things, myself included. So we are constantly doing things. We're still misnumbered a bit. Don't worry about that. Actually, just repeat slides afterwards. So we're only at 47, and you have the entire presentation. There was some extra and things that got cut out that are giving our numbers inflated on the slide count. But I think that about does it for me. Thank you all again for your attendance. This will be and should be available on CRPA's website for further follow-up. I hear speakers cracking. If there's anybody else who wants to chime in who's still on the line, I'm about ready to sign off. But last but not least, like I mentioned, this will be available on CRPA's website for you to follow back up on. I would suggest if you're further interested in this information, turning back into the regulations webinar we did back in January. Like I said, these regulations are very minor changed from before. Thank you for that link. And it's on YouTube, I guess. Wow. But nevertheless, I think I can hear Chuck clearing his throat. Chuck, you want to chime in?
Folks, the only other thing, thank you everybody who's already engaged. I see a lot of you guys are definitely already supporting NRA, CRPA. You're already getting the information. If you're not, though, that's information is the key to being able to be effectively engaged. So, CRPA.org. My Facebook page is Chuck Michel, California Rifle and Pistol Facebook page, NRA Members Council Facebook page, Gun Owners California Facebook page. Facebook seems to be the way that everybody's getting a lot of their news these days, but you can also get the emails at each of those websites. So please get involved. Sorry about the slide numbering being off there. And thank you all for those questions. We will be trying to go through those and sending an email to everyone with answers to any questions we didn't get a chance to answer. Frankly, it'll probably take a couple of weeks. There's a lot of detail to this, as you all now painfully know. So anyway, thank you, everybody.
Yes, Chuck, a couple of weeks.
Yeah, a couple of weeks, a month maybe, because we are still trying to get. Everybody in the office is working to get lawsuits together. So, Gunmageddon is going to meet Suapalooza. So the NRA and CRPA and my legal team and the NRA's team across the country, we're all doing it for you guys. So, we can try and take this state back. Remember, Texas used to be blue. So if everybody engages and we get all our friends to engage, it's not impossible. It's going to take a while, and folks shouldn't confuse lack of success with a lack of effort. Everybody's engaged to try and to get it done. So grassroots help is the most important thing we can ask you guys for now. Anyway, thank you everybody for attending. I think that wraps it up, and we'll see you next time. There'll be another one coming soon. Thanks.